I'm Tom King, the founder of Toolkit.law, and we are here on an exciting topic right now for our CLE webinar for the 80 countries with English-based legal systems. We're here with the law firm of Pillsbury, Winthrop, Shaw and Pittman. They are a full-service global law firm with a specialization in arbitration and technology. Gary Shaw, I believe you're in the Washington, D.C. office, correct?
I am, yes.
And Carolina Plaza, you were in the Miami office, correct?
In the Houston office.
In the Houston office. But you have, oh, that's right, you went to law school in Miami.
Yeah,
But
that's correct.
Carolina, you have offices globally, correct?
That is right. Yeah.
Okay. And so today as I'm going to start sharing my screen, we are going to talk about differing communication perspectives. So let's go ahead straight to it. Which of the two of you has the green column?
That will be me.
Carolina, what do you want us to, as we follow along with this help sheet regarding alternative dispute resolution, let's go ahead and look at the first box for these 7 minutes on this column. What do we need to know about official and working language?
Well, the official language in arbitration is always going to be established in the arbitration agreement or clause. And basically, that language is the language under which the tribunal and all the submissions are going to be submitted to the tribunal. The tribunal is going to render the award. Now, the working language is the parties' language. So they may be the same, but most of the time they're not. So for instance, if you have a dispute between English investors and Spanish company or Spanish state, then the Spanish will be the working language for the people from the Spanish state, and English will be the working language for the people of the English investor company.
Not only have I never thought of that, but what I think is fascinating, I think of countries where they have dual languages, like in Pakistan, which by population is number 3 in the world of Spanish speakers. All law school in Pakistan is in English. All laws must be published in English and in Urdu. All judges must be bilingual, but I'll bet when they work, they're working in Urdu, but they're arbitrating in the official language of English.
Exactly. So that is very interesting. And that's when you, as a person that is in the arbitration proceeding or the dispute resolution proceeding, you need to be aware of those differences between the official and the working language and make sure that everyone is on the same page.
Perfect. What's next?
And with that comes, of course, the client proficiency. So if your client is, for instance, Spanish speakers and the official language is English, then you have to evaluate how your client or the proficiency of your client in the official language. If not, if the client is now proficient in the official language, you should hire a translator or an interpreter who is going to help your client and the team of your client to better understand and transmit their arguments and what they want to transmit.
Okay, I'm really curious about this. Google Meet and Zoom now are using artificial intelligence to do live transcriptions of live events. Are there any requirements? Do they have to be does it have to be live, or can it be artificially intelligence driven translations? Are there different certifications that are necessary, or is that part of what you agree to in the agreement?
That's part of what you should agree on the agreement. Basically, the parties should agree whether they're going to use artificial intelligence or the tools they're going to use when it comes to translation, or even like platforms. If the hearings are going to be a virtual hearings, there's some platforms that offer also simultaneous translations. So for instance, I'm aware of Teams, I'm aware of Zoom, that they offer that kind of services. So they should agree on those platforms, and also about how precise is the translation.
I'm curious, are you aware of any arbitrations in which they used computers to do the live translation, or have you ever encountered that yet? Because it's coming if not.
I have also the privilege of speaking Spanish So most of the cases that I've been in are Spanish and English. So I have not seen that yet, but I'm aware of like Zoom having that ability of translating.
Gary, are you aware of any or have you participated in any?
I haven't seen any where AI or a computer was doing the translating, but I have used sort of Google Translate to listen as a meeting is happening in Spanish if there's no translation available. I've used Google Translate and it works. I mean, you can, it's not perfect, but you can get the gist of what's being said.
Oh, in Google Meet, I've done live closed captions in online mediations.
That's probably a better way to do it. I've just used sort of I've let Google Translate listen, but I'll take your recommendation.
Okay, as we continue, Carolina, where else do you want us to look on this help sheet?
So let's look at, for instance, the documentary evidence, and that basically goes back to what we were saying. So if we have sometimes documents that are, for instance, in one language that is not the same language as the official language, we should make sure that the translation of that document is proper, is accurate. And with this, we also have to be aware of the cost that this may cost, on the party that is going to submit those translated documents.
So you're
Um,
saying that in arbitrations, especially international arbitrations, the arbitration may be done in one language, but the document that preserves it, the arbitration award, would be in a different language, and you got to make sure that it's completely faithfully translated.
Yeah, that is right. That's what should happen. You
Oh
can
my
have
goodness.
both. You can have the original document and the original language, and then you should submit, if the original language is not the same as the official language, you should submit the translation, the accurate translation that you agree on.
You have about 1 more minute for this green column, but I had never thought of that. Go ahead.
Yeah, and the last thing that I would like to talk is the cross-examination and the witness testimony. Basically, it's the same thing. Just make sure the language of the witness speaks Spanish, and you're gonna, I guess, cross-examine in English. You have to make sure that the witness is gonna be comfortable with that and is gonna understand everything that is gonna be said, and that he can express himself or herself as well proper in that language. If not, you should have also an interpreter.
Carolina, what is the most number of languages you've ever had in a single arbitration?
I would say for me has been Spanish and English. And I have to read sometimes French. Well, not read, but like translate it into Spanish or English.
Oh, my stars. How fascinating. Okay. Next, Gary Shaw from the Washington, D.C. office. Your column is international arbitration with different cultures and ethnicities.
I think we're going to keep on Carolina for that one, and then I'm
Okay,
going to take
great.
the last two if that's okay.
Carolina, as we switch to the right column, as everyone's following along in their help sheet packet or on the Toolkit.law website, walk us through this column.
Yes. So basically here, what we wanted to convey is the importance of knowing the background of the parties and even arbitrators that you're going to be facing. Uh, and this is important for different reasons. The first one is communication. And with communication comes verbal, non-verbal communication. So for instance, in some cultures like United States, it's very usual to have people communicating in a very direct way, while in other cultures like China or Asia cultures, that type of communication so direct may be seen as aggressive. So just be mindful of that kind of those kind of like differences in culture is important
Oh,
in
for
arbitration.
those of us who've done business in Japan and China, you better be sure to bow in Japan, but don't you dare bow in China. The first thing
Correct.
the first thing they'll say is, "We're not Japanese." Okay.
That's right. And also with that comes, everything that comes with it. Like, what are the things that they're used to, eating, for instance, even the small things as snacks or the food that you're gonna offer to these people from different backgrounds. That's very important. The dietary restrictions. And also, of course, with that comes that Gary's gonna talk about that later, but religious differences. What what is important for some people to wear when they're in this kind of proceedings, and why is that important, and respect that.
Or taking breaks for prayer times.
Exactly, or taking breaks for prime times. That's very important. So I would say that just in general, we just have to be in those proceedings, be aware of everything that comes with the fact that we are in an international like a system and proceedings with international parties and different backgrounds, and just be mindful of that differences, and also be mindful of the bias that we may have during those proceedings, dealing with different people with different backgrounds as well.
Okay, between the two of you, what's the one biggest mistake you ever made, like a cultural mistake or a dietary mistake? Can you think, or something that you observed in a mediation that you go, oh, they shouldn't have done that? Can you think of some story?
Yeah, I too have done some work in Pakistan, and
Oh,
sort of to make up or to mix up the two cultures between Pakistan and the Pakistani culture and the Indian culture,
oh,
which are sometimes do not mesh well. That can luckily it didn't create conflict, but I was embarrassed sort of by mixing up the two.
oh, I hope you didn't make a joke about their cricket matches.
I didn't do that. I didn't do that.
Okay, let's go ahead and share the screen again. Um, is there anything on cultural stereotyping or bias? I would think this would be so important.
Yeah, this is very important. And I've been in the position where I'm from Colombia originally, and some people still believe that, just because I speak Spanish, I understand everything from Mexico, and the cultural difference that, Mexicans have, and people from Costa Rica, and just because I speak Spanish, and that's not the case. And sometimes, um, they have this bias. Like, for instance, I don't like spicy food. Just simple as that. I don't like spicy food at all. And people believe that because I'm Spanish, I should love spicy food. And that is not the case. So that kind of stuff, just having that, awareness about, even though you may speak the same language, you're still from different backgrounds and different, cultures, and you should be aware of that.
It's like when I was in Costa Rica and I said derecho, they say, this isn't Mexico, it's directo,
Exactly.
right?
Yep.
It's not troca, it's camioneta, you know,
Exactly.
right?
That is the right. Yes, that is
Boy,
the
did
correct.
those Costa Ricans set me straight that I needed to speak Spanish, not from their perspective, speaking Mexican,
Yeah, exactly. So
right?
that happens a lot. Yeah.
You bet. Oh, and I've certainly dealt with stereotypes and things like that as a mediator, but not adding the complication of multiple languages usually. That is pretty wild. Okay, let's go ahead and switch back now to the second page. Gary, I believe this is your area.
Yes, it is. You want to start with the with the blue column?
Perfect. It says international arbitration with differing orientations.
Yeah, and I think, when I read orientations, I think biases, right? We all kind of come to an arbitration, or we all come to any dispute resolution forum with some of our own historical, personal, cultural biases. And so really, the theme of this blue column, I think, is, to be respectful, to understand what I just said, that everyone comes to the table with different biases, and you have to be mindful of your own and respect others. And so the first one, gender perspectives in arbitration. Some cultures, I hope this isn't too many cultures, but some cultures still place a hierarchy on men over women, and that you're not going to change that in the arbitration, and it's not the lawyer's job to change the arbitrator's mind on that, or the other attorney's mind. The lawyer is there to represent a client in a dispute, and so if you encounter um, opposing counsel's bias or an arbitrator's bias, you have to be respectful and be professional, and don't address it unless it's absolutely necessary. But be respectful, get through it, and at the end of the process, at the end of the proceeding, is when you can address those biases. I think skipping down to the bottom, the LGBTQ plus considerations are really important nowadays, and it's not necessarily that the arbitration is going to, or that the attorney's sexual orientation is going to be raised in the arbitration, but maybe the lawyer or even the arbitrator expresses him or herself a different way. Maybe a cis male has his fingernails painted. You see that nowadays in the younger generations. I think the right thing to do is, if that takes you by surprise, just be respectful, be professional, understand that that is just a different form of expression by someone with their own cultural biases.
I'll never forget when I had my first mediation between two men in Texas who were married. And I told them, I said, hey guys, I'm straight, I'm conservative, but I owe you a duty to be respectful, and I'm going to need your help because I'm nervous. I just said, I'm nervous. And I'll never forget, I was doing the drafting, and in Texas, we would say husband and wife. And I'm like, I don't know what to call you in the document. And I'll never forget, one of them was an attorney. He said the smartest thing. He goes, well, my name's Bob, so why don't you call me Bob in the document? And he's Sam. Why don't you just use our names? And I'm like, duh.
Yeah, that issue is that question is coming up a lot with the use of pronouns these days, and or any sort of LGBTQ plus bias or difference that you see. And it never hurts to just respectfully ask, what pronouns shall I use? Or can I just call you by your name, Tom, as you said? But it never hurts to ask. It's much better to ask than it is to assume. And I think if there is an uncomfortable moment, just a polite question will take care of that.
And we have to remember, as legal professionals, you have to be more concerned about that than in a mediation, right? Because in a mediation, nothing's going to happen unless both sides agree. But if you say something that impacts the arbitrator, right, they're going to make a ruling, right?
Yeah, that's right, and that's certainly the arbitrators' cultural biases is something that the attorneys need to take into account even before you come to a hearing. Know who your arbitrators are. The arbitrator should be unbiased and independent. That's the nature of an arbitrator's job. But arbitrators are repeat players, and so you can learn from historical information whether the arbitrator may be biased or something the arbitrator has said in a hearing, and that's a good way to prepare so you can be ready to address those biases in a hearing or after a hearing if it's truly a problem.
For many of us who are solo practitioners or practice in certain areas, we're used to there being one arbitrator. How often in an international setting, Gary or Carolina, is it a panel of arbitrators?
So in the type of arbitrations that Carolina and I do a lot, which is investor state arbitration, where the plaintiff is a company and the defendant is a country, those arbitrations, most all of them rely on panels of 3 arbitrators, where each party picks an arbitrator, and then by some agreed mechanism, the president or the head arbitrator is chosen to sort of lead the panel. And arbitrators come with their own political views as well. Some arbitrators may be biased towards some cultures. And if you represent a Latin American state, you have to think about those biases before you choose those people to be on your tribunal.
Is there anything else on the left column, Gary, that we still want to cover?
I think we've covered it.
We're doing great on time. Let's switch to the right side. The peach, the international arbitration with differing religious beliefs.
Yeah, and this I think is the same theme, maybe even just more so, right? The theme of all of these boxes is be respectful. Understand that your opponents, your arbitrators are coming to the table from different religious backgrounds. They may not have a religious background at all. They may be very devout, and you just have to be prepared to be respectful in every situation. I think the second box down is really important because you never want to schedule an arbitration in a way that conflicts with religious holidays for one of the parties, one of the attorneys, one of the arbitrators, or one of the interpreters. You want to make sure that every person in that arbitration, that their religious practices are respected and that they have the freedom to practice those religions. So sometimes you need to pause in the afternoon or at a certain time of the day to allow certain members or certain participants in the arbitration pray. There should not be any question that those accommodations are made 100% all of the time, even if it may be something that is not so mainstream or not so standard of a religious practice. Yeah, accommodations need to be made. Dietary restrictions are just one example of that.
Okay.
And then sort of towards the bottom box, when you want to avoid when you're presenting your arguments either in written form or certainly in a hearing. You want to avoid colloquial phrases that may have religious connections because you don't know, and none are coming to mind right now, but you don't know necessarily what the backgrounds of your colleagues are. So you don't want to get into trouble or say something wrong in any way, especially with the tribunal, because Tom, as you said, at the end of the day, they're deciding your case, and sometimes if it's down to the wire, if it's a close call, an arbitrator just may think, it's not I'm choosing one side over the other because of my religious, because one party said something, but it's that judgment call, and sometimes the arbitrator likes one side more than the other, and so you don't want to create that situation.
Okay. Anything else in this column?
I think that's it.
Okay, so I got three different areas of questions. So to Carolina first, and then to Gary. So what did you find were the biggest differences between local or national versus international arbitrations?
Wow, that's a good question. Everything is different. Yeah, everything is different. But I guess what surprised me the most, for me at least, was the fact that at least in the cases that we are in, is most of the proceeding and the submissions are in both languages. And normally that international arbitration, that does not happen, it's just English, right? And I like it. And the fact that, for instance, if you're going to go to a hearing, it's the same thing. So you have one party that is expressing and exposing his or her arguments or his arguments in one language and the other party in a different language. And then you have the translation happening at the same time. So all these parties in the same proceeding is something that doesn't happen in national arbitration. So that was something that was surprising for me.
So Gary, how's your Spanish?
Improving, but it's not as good as yours, and it's certainly not as good as Carolina's.
Okay,
but it's
so
improving.
and of course, Carolina, you have to think about who your team's going to be, right? Because you don't have time to be translating for the weak link like Gary trying to get his Spanish better, right? Or me.
I'm okay with that. I will never say no to translating. That's fine with me. Because I do believe that it's important, especially when you are in a team that everyone understands what is being said in an accurate way. And also because sometimes, especially, well, in every single language, but sometimes when someone is presented in Spanish and you want to translate into English, at least I put the effort into making sure that the word that I'm typing or saying to my colleagues is the same or the accurate word for the word that is being said in Spanish. And that takes time, and I'm okay with doing that one.
Have either of you done jury trials?
No.
And I've been on a jury. I've never done it. I've never.
So I grew up as a prosecutor with the district attorney's office, and including juvenile capital murder. And I've never done an arbitration. And I'm wondering, do you have any thoughts of what maybe the difference is between, obviously you're not picking a jury. Are there any obvious things to you that might not be obvious to other people if they come from a jury trial perspective or trying trials to judges? When they go into their first arbitration, what is the thing that's going to shock them the most?
The juries find facts, and you need to persuade a jury as to what happened, right? And I think more in an arbitration, there is an aspect of what happened, but it's a little bit more legal too. It's did these acts, most of the time, which we know happened, breach the contract? Was there a breach of contract? And so usually with arbitrators are a bit more specialized, both in the law and oftentimes in the subject matter of the arbitration. So if it's a lab dispute, science-based dispute, sometimes you have engineers who are also the arbitrators, so they understand the lingo a bit. That's obviously not the same with jury trials.
And of course, I would think that they would move much faster.
Arbitrations? Sometimes, yes. Sometimes they can. It depends on the arbitration. Our arbitrations don't have, you can't appeal an arbitration award. You can challenge it, which a lot of people do, but you can't appeal. And so that shaves off a lot of time usually. But an arbitration can be just as complex as a litigation dispute. And so it can take a little bit more time.
So last question, is we're doing perfect on time. What is the status of arbitrations that occur online versus on site or in person? Is online really coming forward with arbitrations, or is there still, like, I would suspect in North America, in family law, that 2/3 of all mediations are online, maybe even higher. I mean, where's the state of online arbitration versus on-site, Carolina? Sorry.
That's okay. Well, I would say maybe Gary can answer this better than I do, but that I can. But I would say that it's probably online hearings are happening all the time, and I guess since COVID happened, virtual hearings were made available for everyone. I think that people are picking those more than instead of like traveling because of the cost that means for the parties. But I do believe that also in-person hearings are happening, but not as often as they used to happen.
Yeah, to add on to that, I think there's several different hearings, or there can be several different hearings in an arbitration. There can be a hearing where it's just the attorneys talking to the arbitrator, or it could be the hearing where, just to sort of get everyone's ducks in a row, an administrative hearing. I see more of those being conducted online because, as Carolina said, it's not really cost effective to have everyone fly to London just to talk about a schedule. So that can be easily done through Zoom. However, evidentiary hearings, I think the community still really values evidentiary hearings. The arbitrators like to see the witnesses in person. They like the witness to sit in front of them and answer questions from the attorneys, preferably with the attorneys in person too. We got really good at doing it online during COVID, but that was just sort of a way to get through COVID. I think we still really much value in-person evidentiary hearings.
You bet. Gary, can you summarize again for us Pillsbury, Winthrop, Shaw, and Pittman what type of a firm you are, and where are your offices globally?
First, Tom, thank you for the opportunity to participate. This is great, and we're looking forward to the success of the toolkit. Pillsbury, Winthrop, Shaw, Pittman is a global law firm. We have offices all around the United States. In London, we have a couple offices in Asia, and we just opened up a small satellite office in Saudi Arabia. So we are growing. We are full service. We're litigators. We're regulators. We do a lot of work in the technology space, Silicon Valley and tech. We do arbitrations. And in DC, we do a lot of construction litigation.
Super. Well, Carolina Plaza and Gary Shaw, thank you. And that concludes this CLE webinar.